He taught our son Rohinton, who always mentions this. But what makes a lawyer eminent? It was in October 1985, many years ago, that to a law organization called Law Asia, which was holding the 9th Law Asia Conference in New Delhi. They all have been presidents. Bhasin, the current president, Prashant Kumar of Law Asia, is a very important body. The then Secretary General of the Commonwealth, Sir Sridhar Rampal, sent this stirring message. In it he said, I am urging you, he meant the lawyers attending the conference, to wander into pastures beyond the lawyer's domain. I ask in return, by what superior law are its gates locked against you? And I remind you, we are heirs to a noble tradition of intellectual inventiveness in our response to changing needs, unquote. I like the phrase, noble tradition of intellectual inventiveness in response to changing needs. This is what makes a lawyer eminent. Ordinary people may crack jokes about lawyers. They often do. But the majority of people see lawyers as more equal than themselves. They regard lawyers as trained to use the freedoms granted by the country's constitution, as persons who know better than ordinary people how to use these freedoms. In times of grave crisis, constitutional or national, they look to lawyers and associations of lawyers to see how they react. They have done so in the past and continue to do so in the present. Notwithstanding all the lawyers' peccadillos, notwithstanding that on occasions, at the drop of a hat, we lawyers will not work for those who pay us. There's a reason for this. I believe it is because over the years, without the support of legal guarantees other than Article 22(1), the lawyer in India has shown his true mettle, that he or she is at his best when the going is rough. And they have suffered. One of them has been a judge who we are honoring today in the Bombay High Court, who during the internal emergency of 72 to 75, had to resign because he belonged to a particular political party and was proud to say that he was. Now, that's the sort of thing that we have to be very careful of. And that's why we are meeting today. That's why we are honoring all our lawyers. I believe that an impartial administration of law is like oxygen in the air. People know and care little about it till it is threatened to be withdrawn. When it was withdrawn in India during the internal emergency declared in June 75, and you must never forget it. If you don't know anything about it, please read about it, because you must be attuned to it. You must know what had happened, how the whole system had broken down fortunately for a few months exceeding a couple of years, but it had broken down. Therefore, you must know about this. You must know about the emergency, the internal emergency of June 75 to March 1977. You must read about it. The organizations established during this period for upholding civil liberties are flourishing today. Citizens for Democracy, People's Union for Civil Liberties, People Union for Democratic Rights, and a host of other NGOs are manned and led mainly by lawyers. But these noble traditions of intellectual inventiveness are put to test today with the escalating advances in technology that could not even be imagined in the year 1985. All of us have been recently rubbing our hands with joy that a constitution bench of 9 judges recently unanimously affirmed that the right to privacy is and remains a fundamental right. But its application to modern technology is a crying need of the hour. My granddaughter's husband, Rohan Alva, an alumni of Harvard, sent me a few days ago an online summary of a most recent case being argued by the before the US Supreme Court, all 9 judges. The argument bears the date November 29th, 2017, just 5 days ago. And the analysis reads as follows. The Supreme Court heard oral argument this morning in an important privacy rights case. The defendant in the case, Timothy Carpenter, was convicted and sentenced to 116 years in prison, because there they have consecutive years of prison, for his role in a series of armed robberies in Indiana and Michigan. At his trial, prosecutors introduced Carpenter's cell phone records, which confirmed that his cell phone had connected with cell towers in the vicinity of the robberies. Carpenter argued that prosecutors could not use these cell phone records against him because they did not have a warrant for them. But the lower courts had disagreed. And here is the punchline. Today, the Supreme Court seemed more sympathetic, although they were clearly uncertain about exactly what to do. As Justice Stephen Breyer put it at one point, this is an open box. We know not where we go. One of the judges, Sonia Sotomayor, lady judge, was sympathetic to Carpenter. She tried to remind the court of the stakes involved in the case. She said, although this case is only about the historical cell site records, which indicate where a cell phone is connected with a tower, technology is now far more advanced than it was even a few years ago when this Mr. Carpenter was arrested. A provider could someday turn on my cell phone and listen into my conversations. This is what she said. Her companion, Senior Justice Breyer, echoed the same idea. He agreed with government counsel that there is a general rule that information shared with a third party would not be shielded from disclosure, but he proposed an exception to that rule to account for significant changes in technology. Breyer said that cell phone records at issue in this case are highly personal, more like medical test results than that of commercial information, because commercial information is, of course, permitted to be disclosed under American law, but not medical test results. Breyer, who is now famous for his long hypotheticals in arguments, summarized the dilemma facing the justices. How do we draw the line, he asked. Government counsel gave a prompt response, telling the judges he didn't think the line can be drawn coherently. Another judge, Justice Alito, pointed out that under the Supreme Court's case law, evidence from a search does not have to be excluded when the search was conducted pursuant to a statute that is later deemed unconstitutional. But, he added, this case will nonetheless be a significant one for privacy law. You will notice that in this summary of arguments, a very important principle emerges, that judges keep striving for and deal with, even in cases of bad people, because very often the law for good people is there laid down. You must always remember that and never forget it. Courts are and should be always conscious of the effect of its judgments on future cases. It is like the cases like the one I just recalled that test the mettle of all you young lawyers who strive to be eminent and who will ultimately become eminent, receiving due recognition for your eminence. The search then is not merely for proficiency in the profession. The search is for lawyers in India who are excellent in their proficiency, which ultimately will make them eminent. As to what should be the image of a lawyer, I leave you with what a famous law lord long ago, Lord Scarman, told a conference of the Law Society in New Zealand, a conference to which I was invited. At this conference, held way back in 1984, Lord Scarman expressed some home truths about our profession, which are as relevant today as they were then. He said, lawyers must not arrogate to themselves a position of dominance in the society they serve. Always remember that. But their position as servants of society, he said, is indispensable. The ordinary tough, robust Englishman, Scarman went on, whether he runs a petrol filling station in Shropshire or tells or sells suspect goods from a barrow in East End of London will say, although he will not put it as delicately as I shall, that the law is an ass. But he will never say lawyers are idiots. He may say they are too expensive. He may say they are overbearing. He may say they are fortunate, far too wealthy, and exacting in their demand for fees. But he will and does respect them. And he ended his speech with these words: the law may fall into disrepute, but lawyers do not, unless they themselves create. Mark you, the law may fall into disrepute, but lawyers do not, unless they themselves create the circumstances in which they can become disreputable. Yes, we do become dishonorable when we treat the profession as a business, and we give the impression that we will do anything, literally anything, for payment. We become disreputable and dispensable when we choose at our own pleasure not to appear for clients in courts, tribunals, and authorities before which we claim a right, a statutory right to practice. But with all this, please remember that in the end, an independent legal profession can never survive without public support, neither in India nor elsewhere. Our image with the rest of the public who are not lawyers is vital for our survival. My good friend and colleague of yesteryear, the late Justice Dorab Patel of the Supreme Court of Pakistan, had said in his keynote address to a seminar at Kathmandu long, long ago at the International Commission of Jurists. This is what he said. In the long run, he said, the manner in which judges and lawyers discharge their duties can build up public opinion for the courts, and public opinion is a better safeguard for the independence of judges and lawyers than law and constitutional guarantees. Dorab Patel knew what he was talking about. He had raised a groundswell of public opinion in his favor when he preferred to resign as a judge of his country's highest court, the Supreme Court of Pakistan, rather than take a fresh oath of office a new oath of office to the martial law administrator under the then newly promulgated Constitution of Pakistan. What he said and did added value to the community of lawyers to which he was always proud to belong. I am delighted that the Bar Association of India is adding value to eminent lawyers, and I wish them all the very best.
When Mr. Nariman mentioned about the Honorable Judge resigning from Bombay High Court, I must also inform you, those of you who do not know about it, that when emergency was declared, Mr. Nariman was holding the position of the Additional Solicitor General of India in New Delhi, and he immediately resigned from. Now we have you see, I'm the president of Bar Association of India, Mr. Nariman, but we are all like heading a voluntary organization. But we have now amongst us the official leader of the Indian Bar, that is the Attorney General of India, Mr. K.K. Venugopal, and I request him, you see, to please deliver his address.
Justice A.P. Shah, Fali Nariman, eminent persons on the dais, eminent persons in the audience, my colleagues at the bar, and friends. Our profession has been known from yore as an honorable profession. And I've been wondering as to whether we, the present members of the bar in India, are entitled to call ourselves members of a noble profession.